they pay rent to someone else, and then they die and they own nothing, right? That was it, that was their life, and they have nothing left generationally to give to their children or their grandchildren. And that's a big problem, right? The idea of economic advancement is really sort of underpinned in this notion of creating something to leave to your children. So that's what Ronnie means when he's talking about generational wealth. So I'm here to talk about some simple steps that you can take to protect the wealth that, if you avail yourselves of all of these great ideas and resources that have been presented here today, let's say you do this. And now you are, I'll use a concrete example. Let's take the example of Joe the veteran, G.I. Joe. So the first thing I want to talk about is some steps that you can take to avoid probate when you get older and you become incapacitated, mentally or physically. Does anybody know what I mean by that? Incapacity, right? So right now, I, just like all of you, are the captain of your own ship. I make my own medical decisions for me. I make my own financial decisions for me. Nobody else makes those. I get to make all of those. But let's say something really bad happens. I get sick or I get hit by a bi-state bus, and now I'm incapacitated either mentally or physically, and I can't communicate my own decisions. Well, what happens to my medical decisions? What happens to my stuff? No one can go down to the bank and take money out of my account to help me because I'm the only one in charge of my affairs. And if I'm in the hospital or I'm in a coma and I can't communicate those things, or if I'm older and I have dementia and I lose my mental capacity and I can't communicate those decisions, that is a major problem for people who are still alive but can't make their own decisions. And if you take a couple simple steps with some documents that we call powers of attorney, you can avoid having to go to probate court. Because in my example, if G.I. Joe walks out of here and gets hit by the bus and he's now laying in the hospital in a coma, no one can make his medical decisions for him. No one can go down to the bank and get out money to help him to pay his rent or pay his bills. Now his house goes into foreclosure. Does anybody know, if you don't have a power of attorney, how you solve that problem? If I get hit by a bus and I can't communicate to my doctor or to the bank, and I can't do anything, and I don't have a power of attorney in advance to delegate that decision-making authority, somebody in my family, some interested party, has to go to the probate court, and they have to ask for guardianship, which is court authority over the decision-making for the person, right, or his medical care, where he gets placed. And there's also something in probate court called conservatorship, which is court authority not over your person and your medical decisions, but over your stuff. That could be the same person, it could be different people, right? So if I'm guardian, I get to decide what your medical treatment's going to be. If I'm conservator, I take care of your finances. Well, that's a big, very expensive pain in the butt. And anyone can avoid that if they will do a durable power of attorney. We call it durable because it endures beyond your incapacity. The idea is that you do it while you're alive, of sound mind. In one document, a financial power of attorney, you say, if something happens to me and I become mentally or physically incapacitated, I want Nicole to make all of my decisions related to my finances. And I sign that, and I have it notarized so that everybody knows that that was my signature. And now when I walk out of the building and get hit by the bi-state bus, it doesn't matter. Nicole or my loved ones will never have to go to a probate court or be involved in that guardianship process or that conservatorship process, because I have this power of attorney that says, if that happens to me, I want this person to make my decisions. And you can even have backup people. If Nicole says, no, I don't want to do that, I can pick my sister as second and my mom as third, whoever you want, anybody of confidence. So that's my first free legal advice to all of you is, if you have the means, and you have the wherewithal to do this in advance, it's really helpful to have a healthcare power of attorney and a financial power of attorney, so that if, God forbid, something happens to you and you're alive and you can't make those decisions, you have these documents, because that completely obviates the need to go to court. You never have to go to probate court. That document alone is all that you need. Now, those documents are only good while you're alive. So if I have this power of attorney to Nicole to make my decisions when I get hit by the bus, if in the hospital I die, she doesn't have any more authority to make those decisions for me, right? Now I'm dead, the powers of attorney are no longer valid. So the next part of what probate does is to deal with your stuff when you die. In my example of G.I. Joe, G.I. Joe took advantage of Ronnie DeVoe's VA housing loan program, and Joe bought a house. And it's in Joe's name. And Joe has a car that he uses to get around, it's in his name. And Joe has a bank account, and Joe even started a business with Smart Card. He talked to Jared up here, or Justin, I apologize if
Jacob.
Jacob. And he started a business, Joe. And then Joe is unfortunately struck by the bus, goes to the hospital, Joe passes away. Now Joe's got all this stuff. He's got his house, he's got his car, he's got his bank account, he's got his business. It's all in Joe's name. What happens when Joe dies? No one can touch that stuff.
Right.
No one can sell the house, no one can lease the house, no one can go down to Joe's bank account and take his money out of the account. Joe had his wife as the power of attorney who was going to do those things, but now Joe has died, and those powers of attorney are meaningless. So the bank says, I'm sorry, this is no longer valid, we can't let you take out the money. I'm sorry, you could sell the house before under the power of attorney, but you can't because Joe has died. So now, if Joe has done nothing in advance to take care of this, where does Joe go? Well, Joe's gone, so now his family has to go to the probate court, back to the probate court, right? And we open up an estate for Joe. So, like I said at the beginning, that estate is not determined by an amount of money. It doesn't mean you're a millionaire, you have an estate. If you're like most people and you have a house and you have a car and your bank account, that's your estate. But if you die and it's only in your name, there's only one legal authority that can determine where that stuff goes, and that's the probate court. Unless, and this is my free advice to you, unless you do some stuff, you take some steps legally before you die. I'm going to talk about the house because for most people, the house is their most significant asset, right? You work your whole life, you pay your mortgage, you have a home. That's what most people rely on as their single greatest asset. Sometimes retirement, but usually the house. So Joe has died, the house is just in Joe's name. What could Joe have done to avoid probate so that after he died, in my example, Joe has 8 children. One of Joe's children predeceased him, and that child had 4 children. Okay, so everybody follow me? So Joe's here, he's got 8 children, number 8 dies, number 8 has 4 children. If Joe hasn't taken steps to deal with that house, the state of Missouri has a will for you. It's called the intestacy statute. And it determines where your stuff goes when you die. If you don't have a will or a trust or some other estate plan to say in advance where you want your stuff to go. Well, the intestacy statute isn't really a good way to distribute your property. One, because it's very lengthy and cumbersome. You have to go through this really long probate process. And in the end, it may give your property to someone that you didn't want it to go to, or maybe it's going to be too complicated. In my example with Joe, when he dies, the intestacy statute says when you die, all of your stuff goes to your wife if you're married. If you're not married, it goes to your kids. If you're not don't have kids, it goes to your parents. If your parents are dead, it goes to your brothers and sisters. And the statute goes out along these lines of consanguinity, these bloodlines, until it finds a legal heir to give your stuff to. Well, in my example with Joe with his 8 kids, if Joe doesn't have an estate plan, the intestacy statute says that his 8 kids each get an 1/8 of his house. And the child that died, his 1/8 descends to his 4 children. So now Joe has died and 12 people are going to own his house. A probate court order at the end of that estate is going to say the 7 living siblings and the 4 grandchildren all own the house. Well, that's going to be a nightmare, right? Because now you got to get 12 people to decide. They all own it. How are they going to decide to sell it? Who's going to pay the real estate taxes? It's a big nightmare. So what could Joe have done to avoid this problem? The easiest thing, and this is what you should take away, the easiest thing to protect yourself if you're a homeowner to avoid probate is to do a beneficiary deed. Write that down. Beneficiary deed. You've probably all heard of beneficiary designations, like a POD, pay on death, or TOD, transfer on death on your bank account. Those beneficiary designations are great ways to avoid probate. You can put them on lots of things. You can put them on a car, you can put it on a bank account, you can put it on a stock account. You can do it for a house as well. So if there are vets out here or anybody else that has accumulated wealth during their lifetime in the form of a house, the easiest way to make sure that goes to the person that you want it to is, does everybody know what a deed is? The deed is the document that evidences your ownership of real estate, right? The same way your car has a title, there is a deed for your house. All those deeds get recorded with the land records. It's all public. What you can do is, Joe should have done, Joe could have gone to an attorney or on his own, got a beneficiary deed that says, I, Joe, when I die, want my house to go to my son, Mark. And as long as Joe records that beneficiary deed during his lifetime, he's got to record it while he's alive. He can't do it and stick it in a drawer and they find it after Joe is dead. He's got to record it in his lifetime. But if Joe does that, you don't need to do anything else. There's no probate court, there's no fees to pay, there's no lawyers, it is automatic. As long as that deed is recorded, when Joe dies, who's ever named in that deed now owns the property. So that is my number one piece of advice to anybody out there as a homeowner is make sure you don't die with the property in your own name. The easiest way to make sure that it's going to get to the person that you want it to and you get to choose as the homeowner, you don't have to leave it to anyone else. You can't disinherit a spouse in Missouri, I'll say that. But you can disinherit your kids. If you don't like them, you can leave it to your neighbor, anybody else. But if you record that deed, you completely avoided probate. The other way to avoid probate is a trust. It's a little bit more complicated. That's where you set up something that's kind of like setting up a company. In my case, it would be the G.I. Joe Revocable Living Trust, and Joe would transfer all his property to the trust, and then when Joe dies, the trust distributes all of his property. The third way to plan for an estate is a will. Everybody's familiar with a will. Wills do have to go through probate, unfortunately. A lot of people think that they don't. You do a will, you don't have to go to court. When you die, your original will has to be delivered to the probate court so the judge can make sure it's a valid will. And then there is a probate estate open, and it takes a very long time, about a year to grind through. But these are all sort of a summary of your different actions that you can take now in life to protect the wealth that you may have. So just to recap, and to avoid this case of incapacity, mental or physical, you want to have durable powers of attorney that delegate your decision-making authority to someone you trust. And after you're dead, if you'll record a deed, a beneficiary deed for your house, you don't have to worry about it. It goes straight to the person you want. And if you want to get more complicated or have more control, we can talk about wills and trusts. But that's kind of my 25-cent version of estate planning for regular people. If anybody has any questions after the seminar, I'd be happy to talk to you.
Thank you, Thomas. And Tom gives Veterans Advantage Urgent Care so many community hours, pro bono hours monthly. He's helped so many of my patients. Not only does he do probate, wills, estates, trust, he's family law. So he's kept our families together. He's helped out with child support. He's helped out with divorces. Just our patients knowing what they're going to get, how they should go about things. But the most important thing to me that he's done is he's helped our patients with their children. Their children have not been separated from them. He's helped a lot of my male veterans with the custody split. And it's invaluable to have a Clayton-based attorney right here from St. Louis, grew up in the city of St. Louis. And he really provides us with some good things. He's going to give me a discount for all my veterans, and I will have it posted at the clinic, or you can look online on our site. Our veterans, our family of veterans, because you guys get a lot of money from the VA sometimes. And sometimes you'll get back pay. You'll get your benefits back pay. And that's a lot. And you guys are looking into buying a home. So this is definitely much needed. So when you die, I don't like to say die, when you transition, you will have all your affairs in order. Okay?